Now, Kenya will not allow homosexuality. That's the position of Deputy President William Ruto just days after the High Court allowed the registration of a gay lobby group. The ruling has sparked debate not just in religious and political circles, but also within the legal fraternity. Did the High Court's argument contradict the penal code? Well, Asham Wilu reports.
We started applying for registration as early as April 2012.
In October last year, the Human Rights Watch published this online video showing the struggles of groups advocating for the rights of lesbians, gay, bisexual, transgender and intersex persons in Kenya. By then, the NGO's coordination board had refused to register LGBTI groups, deeming their names unacceptable.
I am at the Central Park waiting for a client who we're supposed to have a meeting with. He needs legal advice on his case. I can't meet him at the office because we don't have an office. So I meet in such public places.
2 weeks ago, the High Court ended these groups' misery, ordering the NGO's board to recognize and register a gay rights lobby group. But the ruling has opened a Pandora's box, turning the debate into a moral, religious, and even political one.
Taifa la Kenya ni taifa linalomcha Mungu. Hatuna nafasi kwa washoga na wale wengine.
Can the minority then claim to have a...
But human rights lawyer Maurice Mbondenyi thinks the biggest question this ruling has left is a legal one.
When the court goes ahead to say that although gayism and lesbianism may be illegal, let us give them formal legal recognition to exercise their right to freedom of association as guaranteed by the Bill of Rights, we are simply saying that, look, let's look beyond the illegality of this group and grant them association. So that means tomorrow we can actually have any other group like the MRC and other groups, murderers associating, coming together and seeking for legal recognition, and they're granted, because that is what the High Court seems to purport.
During the final drafting stages of the Constitution of 2010, the legality of gays and lesbians reached the table of the Committee of Experts, with some scholars calling for the equal rights of these groups.
Sexuality is like a pendulum, a sliding scale. Even if you define yourself as a heterosexual, you probably have a little gay in you. The Committee of Experts that is headed by Mr. Nzamba Kitonga, that is drafting the new constitution, should listen to the inner voice of humanism.
But the Committee of Experts resorted not to legalize homosexuality. Instead, it ensured that a strong Bill of Rights would protect the fundamental freedoms of all Kenyans. In its ruling, the High Court's three-judge bench relied heavily on the Bill of Rights.
Right from the preamble of the Constitution, where we say we acknowledge, the supremacy of the Almighty God, then we also need to come and ask ourselves whether the entire Constitution is inspired by that acknowledgement of the Almighty God. Then we need to ask ourselves, what is our value system as a nation? Is gayism and lesbianism part of our value system?
Almost 5 years ago, Kenyans hoisted a large flag inside Uhuru Park to signify the promulgation of the Constitution of Kenya of 2010. And in those 5 years, the conversation concerning that law has been more of a progressive nature. But now, with the High Court ruling concerning the registration of coalitions of gays and lesbians, Kenya is having to have a more uncomfortable conversation concerning the law. Does the Constitution have gray areas? Is it time to amend certain aspects or certain clauses of that Constitution? And more importantly, is it time for Kenya to have that conversation about the legalization of homosexuality? Asham Wilu, KTN, Nairobi.